Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Daly, Senator Ellison, Senator Flores, Senator Lang, Senator Rogish, Senator Scheibel, Senator Steinbeck, Chair Pezzina.
Present. Thank you so much, and please mark Senator Flores present when he arrives. And we'd like to welcome our audience here in Carson City. I don't see anyone in Las Vegas, but if they decide to show up, they're of course always welcome, and anyone who's following along online. A few housekeeping reminders before we get started. I'd like to remind everyone to please silence all of your electronic devices while in the committee room. I'd also share that members of the public may provide testimony in various ways, all of which are listed on the agenda. And if you plan to testify, please do sign in at the table by the door and provide your card to our committee secretary. Please do remember to turn your microphone on to speak and off to listen, as we may have someone who decides to join us in Las Vegas, and we'll also have others listening in online. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's materials may do so by signing up on Nellis on the legislative website. Also, we'll be viewing materials on our laptops. Please don't view that as a sign of disrespect or inattention. And with that, we are going to move to our first agenda item, and we would like to welcome Chair Marzola from the Assembly on AB 230, which enacts the Audiology and Speech Language Pathology Interstate Compact.
Thank you, Chair Pezzina, members of the committee. For the record, I'm Elaine Marzola, representing Assembly District 21. I am the sponsor of Assembly Bill 230, which enacts the Audiology and Speech Language Pathology Interstate Compact. I will refer to it as ASLPIC. Today, joining me in Carson City is Jennifer Pierce, who's the Executive Director of the Nevada Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board. On Zoom, I should have Nahali Kalfas, Legal Counsel with the Council of State Government, CSG, National Center for Interstate Compact, and also Kelly Mae Douglas with the United States Department of Defense. I'm hoping they're on Zoom. According to the Nevada Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board, there are 1,412 licensed speech language pathologists, or SLPs, and 179 licensed audiologists. Our state population is approximately 3.2 million people. We continue to see a need for more SLPs and audiologists because there is a growing number of individuals with speech, language, swallowing, and hearing disorders across all age groups, particularly the aging population and those who need early intervention services. The ASLPIC is an interstate compact that provides a pathway by which audiologists and SLPs can obtain authorization to practice in states where they do not hold a license. Under the ASLPIC, audiologists and SLPs who are licensed in good standing in a compact member state are eligible to practice in other compact member states via a compact privilege, which is like a license. Additionally, through the ASLPIC, licensed audiologists and SLPs may provide continuity of care as clients, patients, and students relocate. They will be able to reach Nevadans who are currently underserved, geographically isolated, or lack specialty care. It also reduces the burdens for military families in transition. With your permission, Chair, I would like to introduce Ms. Kalfas from CSG. She should also be on Zoom. There she is, who will provide additional information about the Interstate Compact and go through the bill itself. Then Ms. Douglas with the DOD will speak as well.
Please proceed, and thank you.
Thank you so much, Assembly Member Marzola, Chair Pezzina. Thank you so much for allowing me to be here on behalf of the Council of State Governments and the Audiology and Speech Language Pathology Interstate Compact Commission. As mentioned, I do serve as legal counsel to CSG as well as to the ASLPIC Commission. I also serve as legal counsel to a number of other commissions to which Nevada has had the prescience to join, including the Counseling Compact Commission. This particular compact.
Thank you so much. Can you give us your name
similar
for the record as well? And thank you very, very much.
Pardon me. So sorry, Chair Pezzina. Nahali Kalfas. Thank you so much. Sorry for that, for missing that. This compact is the same in form and function as many others that you already are a member of. I would like to very briefly go through a section by section brief summary, and I'll try to go through it fairly quickly, but I will remain available to answer any questions you may have. So at this time, I believe we have Susan Adams online who's going to pull up the section by section summary for me. Thank you. These materials, along with other information, can be found on our website, but I just wanted to briefly tell you about the key components of this compact. Again, like many others, it is a mutual recognition compact. Probably the compact you're most familiar with that is also mutual recognition is your driver's license. The driver's license is an interstate compact that also recognizes a license in good standing from another state and allows for cross-border practice and, again, access to competent care thereby. And in the first section of the compact, we set out a purpose statement, which can be very useful in reminding the Commission of its duties as the governing body of the compact. Section 2 sets out all of the defined terms that are utilized both in the compact and in the very narrow regulations that the Compact Commission is able to make. Section 3 speaks to what is required for a member state to actually participate in the compact. And these were taken from what was essentially the universal requirements that we found across the country during a very lengthy stakeholder process that we go through at the Council of State Governments. For Section 3 in the state participation of the compact, we lay out both audiological and speech language pathology requirements. We have some educational requirements, again, that were in keeping with what was very close to the norm across the states at the time the compact was drafted. We do require some supervisory experience. We require education. You must, of course, also have an unencumbered active license in another member state, another state which is, in fact, a member of the compact. I would like to point out at this point that you actually have right now 35 states in the ASLP compact, including 2 of your neighboring states, Utah and Idaho. That number we hope will grow this legislative session. We also like to remind everyone at this point that the scope of practice of Nevada is respected whenever a speech language pathologist or audiologist is practicing via the compact privilege into your state. They are required to follow Nevada's scope of practice. Section 4 also lays out, of course, the requirements for actually getting the privilege to practice. We are about 4 months, give or take a week or two, from getting our Compact Connect data system online so that this particular compact can actually be operationalized. That data system has been under a build for the past 12 or so months. It is almost complete. We are in the very last sprints of completing that data system so that this will actually operationalize by the end of September is the current projected date. Section 5 speaks to allowing for telehealth, and most compacts, including this one, view telehealth to be but another modality of practice. It requires the same sort of ethical questioning, the same sort of standard of care that you would require of an in-person practitioner. The practitioner must determine whether or not that telehealth is appropriate for that particular patient. And so any state's scope of practice with regard to telehealth obviously would be respected. Section 6 just gives a specific mention of the fact that active duty military personnel or their spouses may actually retain a home state from which they've had to move on through no fault of their own, but through new placement orders. And I know that Ms. Douglas will probably speak to that a bit, but this is something that our valued members of the military have found to be very useful. Next page, please. Section 7 speaks to adverse actions. And with regard to adverse actions, this is a very important feature of compacts, interstate compacts, versus, say, universal licensure recognition laws or model laws, in that in a compact, you have the ability to regulate the person who is practicing in your state just as though they were one of your licensees. Just because they come in under privilege does not mean that the state of Nevada does not have the right to hold them accountable should there be some sort of violation of the scope of practice within the state of Nevada. So essentially, you have under an interstate compact a broader prosecutorial net, in that if someone does have a violation in another state, other member states may look to that action, determine whether or not it also violates their state's laws, and determine on its own whether or not to take action against that practitioner. So Section 7 lays out adverse actions and how that works and how it may or may not disqualify a practitioner. Section 8 speaks to the governing body, which I've previously mentioned, the Compact Commission. This particular compact affords each member state 2 members to be seated as delegates on the Compact Commission. Very important that we lay this out very specifically, because as you probably have heard with other compacts that are in your state, these folks need to be state actors. This governing body is a governmental body.
Ms. Kalfas, a quick question for you on that.
Certainly.
Would it be one member from each state who's an audiologist and another one who's a speech pathologist? Is that why the 2 members?
Correct.
Okay.
Thank you very much.
Thank you so much.
That is absolutely correct. And that is a little unusual. Not every compact has 2 delegates from each state, but this particular compact does have 2 delegates out of respect for the 2 separate professions. Typically, they're regulated together, but the stakeholders felt that that was very important to have that equal representation of both professions. So that Section 8 speaks in much the same language that other compacts speak about the duties, the requirements, the responsibilities of compact commissioners. However, the important thing that we always train our compact commissioners on is to remember that they are on a compact commission as an extension of their duty as Nevada's state actor. So they speak on behalf of the state, and obviously it's very important that they speak to the executive director of any licensing board, that they work closely and keep that licensing board, those regulators, informed as to what's going on in the compact commission. Section 9 speaks to the data system, which I previously referenced. Our data system will be called Compact Connect. There's information online now about Compact Connect. Again, that's been a venture between 3 compact commissions, but the information between the 3 separate commissions, of course, will be firewalled. We've been very fortunate to have assistance from the Department of Defense in building that data system as well. Next page, please. Finally, we have Section 10. That's the rulemaking section. It is very robust. It works in much the same way that rulemaking works for your state boards and agencies. There can be no rulemaking that speaks to anything other than that which is specifically and narrowly authorized by the compact. There can be no rulemaking in the area of scope of practice, because the commission has no authority to be able to unilaterally require of another state anything other than what that state deems to be its scope of practice. So these rules that you see typically speak to things like how you access the data system, how we engage in the work that we do to ensure that the compact is there. It doesn't actually change any of the requirements in any of the states. This is a modern axiom of law today. It has been upheld by the United States Supreme Court for a number of years, several decades. So it's a common delegatory authority to this commission. But again, it lives in that very narrow area of only that which is directly authorized and cited in the compact. Section 11 speaks to how we engage in dispute resolution and enforcement. And obviously, we all want to work together. I'm happy to say that there's only been one enforcement action that did go through the whole processes. It was not in this compact commission. It was in another compact commission. But out of all the compact commissions that are out there, there's only been one enforcement action. Section 12 speaks to the date of implementation. That has already occurred because we did get 10 states into the compact early on several years ago. So we are a live compact commission. We just need to operationalize with that data system, and that is projected currently for September. Section 13 speaks to construction and severability, very standard term, and essentially says if there's some part of this compact which does not apply, or if there's some sort of ultra vires concern, that the rest of the compact obviously does apply. Again, with regard to rulemaking, bylaws, anything of that nature, very robust rulemaking requirements of notice and opportunity to be heard, vote by the full commission, and public comment. And again, all of those rules must be directly authorized. Section 14 speaks to the binding effect. This compact is not just a law, it's also a contract. So both the Compacts Clause of the United States Constitution and the Contracts Clause of the United States Constitution are what create our ability to draft these documents. They've been around for a very long time, since the beginning of the country, and they do work much like contracts, in that any one member state cannot unilaterally break the agreement that's been made between the states. So this is the mechanism by which we can really protect the sanctity and the federalist notion of the sovereignty of each state that is a member to this compact. I want to be respectful of your time, Chair, and so with that, I'm happy to answer any questions from the committee.
Thank you so much. We're actually already at 15 minutes, but I know I'd really love to hear from Ms. Douglas, and we like to have her go ahead and speak to us now as well. So, Ms. Douglas, thank you.
Good morning, Madam Chair, Mr. Vice Chair, and members of the committee. My name is Kelly Mae Douglas, and I work at the Defense State Liaison Office within the Office of the Undersecretary of Defense for Personnel and Readiness. On behalf of the Defense Department and military families stationed in Nevada, I would like to express our support for the policy addressed in AB 230. State policies enacting interstate licensure compacts, such as the ASLPIC, relieve one of the many stressors of frequent military moves by enabling military spouses to transfer their licenses more quickly across state lines and obtain employment as soon as they relocate to a new duty station. These policies facilitate greater career sustainability for military spouses, improving their families' financial security and overall resilience. Notably, interstate licensure compacts benefit not only military spouses, but also apply to all eligible professionals, to include active duty service members, members of the reserve components, veterans, and civilians. By enacting AB 230, Nevada would have the opportunity to increase its workforce available to serve the local community while supporting military families. The Defense Department is very appreciative of Nevada's ongoing commitment and efforts to support members of the military community who sacrifice much in service to our country. Thank you for providing me the opportunity to provide comments in support of this policy proposal. Thank you.
Thank you so much to Ms. Douglas and Ms. Kalfas. Is there anything else?
Thank you, Chair Elaine Marzola. For the record, we stand for questions.
Thank you very, very much. I did have one question to start us off, and it was just because I missed it, and it was information you had shared. You had mentioned there are currently 1,412 speech-language pathologists in the state, and then you had mentioned the number of audiologists, and that was just me missing it. So I wanted to get that from you.
Thank you, Chair. For the record, Elaine Marzola. 179 licensed audiologists in the state of Nevada.
Okay. I remembered it was a much lower number than the other, but I couldn't remember what you said. So thank you for that. Do we have any other questions from the committee? All right. It doesn't look like we have any other questions. So with that, thank you so much for the presentation. We are, just because it's deadlines and crazy times, we're going to do 20, 20, 20. So we'll take 20 minutes of support, 20 minutes of opposition, 20 minutes of neutral. And we do ask everyone to keep your comments to about 2 minutes so that we can ensure that we can hear from everyone. So with that, we will have you go ahead and begin testimony in support.
Thank you, Jennifer Pierce, for the record, Executive Director of the Nevada Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board. And for the record, the board is in support of AB 230. Thank you.
Good morning. My name is Shauna Ross, for the record, SHAWNAROSS. Thank you, Madam Chair and Committee, for considering this bill. I am here representing the Nevada Speech Language Hearing Association in support. I am also a speech language pathologist. I opened a pediatric private practice in Reno 19 years ago this month. My job is really amazing and wonderful, but one trend that I've seen over the years is finding employees, and the shortage of SLPs in Nevada affects every practice setting: schools, private practice, hospitals, skilled nursing facilities. Right now, our wait list for private practice in Reno, especially for after school hours, is quite long. And one of the hardest things I do is take calls from families knowing that the kids need these services and we could help, but we do not have the capacity. And through the association, we hear that it's even worse in Las Vegas. So thank you again for your consideration.
Good morning, Chair Pazina, members of the committee. For the record, my name is Taylor Avery, spelled Tayloravery, and I'm the Manager of Political Affairs for the Vegas Chamber. The Chamber supports AB 230. This legislation is a step forward in addressing workforce shortages in Nevada's healthcare and educational systems by allowing qualified audiologists and speech language pathologists from other compact member states to practice in Nevada. This bill helps ensure that our businesses, schools, and healthcare providers have timely access to essential communication and hearing health services. Thank you.
Chair and committee members, for the record, my name is Andrew Lee Pilbit. I'm the chairman of the United Veterans Legislative Council for Nevada, representing the 250,000 veterans in our state, and we support most combat pacts as it helps our veterans that have no choice where they're being stationed, and it allows their spouses to keep in the career that they've selected, and we support 230 as it spells out our active military. Thank you.
Thank you, and thank you so much for your service.
Good morning, Chair, members of the committee. Sheila Bray with the University of Matarino. We too are in support of this bill as it supports workforce development and access to care. Thank you.
Thank you so much. I don't see anyone else in Carson City, and I don't believe anyone has joined us in the room in Las Vegas. So broadcast, we are going to head to you. Do we have anyone on the line in support of Assembly Bill 230?
Thank you, Chair. Your public line is open and working. You have no callers at this time.
Okay, thank you so much. That will move us into opposition of Assembly Bill 230. I don't see anyone coming to our tables in either location. It would be quite a miracle if they did in Vegas since there's no one in the room. So broadcaster, back to you. Anyone on the phone in opposition of AB 230?
Chair, you currently have no callers at this time.
I'm going to stick with you, broadcast. I doubt it, but in the last 5 to 10 seconds, has anyone joined in neutral on AB 230?
Thank you, Chair. Your public line is open and working, but you have no callers at this time.
Thank you so much. Is there anyone in the room who'd like to testify in neutral on Assembly Bill 230? I don't see anyone coming to the table. So do we have any closing remarks? Okay. Well, thank you so much. It's always great to see you here, Chair Marzola. And I might add that Assembly District 21 is also nested in Senate District 12. So I know it's a beautiful district. And with that, we will close the hearing on Assembly Bill 230, and we will move into the hearing with Mr. Adam Plain on Senate Bill 503. It wouldn't be a day if you weren't in the room, and now we even get to hear you present in our probably final meeting.
Thank you, Madam Chair, members of the committee. For the record, Adam Plain, Plain, with the Nevada Division of Insurance. It is a pleasure to be here today in what may be my last appearance before the committee, saying something other than neutral testimony. I also get to combine everyone's two favorite hearing topics, insurance and state financial administration. This is going to be a wing banger, I can tell you. Senate Bill 503 is coming out of the Committee of Finance based on the division's budget close this session. The bill, in brief recap, is very short, 2 sections. Starting with Section 2, it proposes to eliminate the account for regulation and supervision of captive insurers and move the funds from that budget account into the Fund for Insurance Administration and Enforcement. Section 1 does the same with the captive premium tax override, so to speak, that goes into that account. Some background real quick. Nevada started regulating captive insurers back in 1999. When captive insurers first were allowed into the state, the industry wanted captive insurers to essentially pay their own way. The Division of Insurance is an enterprise-funded agency, right? We exist off of fees we charge to our regulated entities, and the same is true for the captive industry. So a specific fund was created so that when captive insurers paid their premium tax, 25% of the premium tax would go into the fund to fund positions within the Division of Insurance to regulate those insurance companies. And the remaining 75% of those premium tax funds went to the state general fund. And that relationship existed very well for the better part of a quarter century. Unfortunately, over the last decade or so, we've had some changes in the captive industry. The IRS has decided to take a specific look at captives that they qualify as 831B micro captives as participating in transactions of interest that they are concerned about. Specifically, there are some actors that perhaps were using captives to sidestep federal estate planning laws. So they issued some guidance that went through a regulatory and litigation process and eventually went into effect in 2024. What that meant was in 2010, Nevada had 125 registered captives in the state. In 2015, we were up to 159. In 2020, we were up to 172. And for year 2024, we are down to 102 registered captives. Most of those captive losses are a result of this IRS scrutiny, and they've been offshored to the Isle of Man, the Bahamas, Bermuda, so on. Because of that, the captive premium tax inflow has dropped drastically. So the 25% amount that goes to what is budget account 3818, the account for regulation and supervision of captive insurers, has dropped considerably as well. During the close for 3818, it was determined that that budget account will be technically insolvent, probably by the end of this biennium, and that something needed to be done to rectify that situation. The division proposed closing budget account 3818 and moving all of those activities into our main budget account 3813. We have enough inter-account transactions already with reimbursements for telecommunication services and office space and whatnot, that it really doesn't make sense to have that specialized captive insurance budget account anymore. So that's what Senate Bill 503 is proposing to do, is to close account 3818, roll it into 3813, and the division will continue to pay for those captive insurance regulation activities out of our primary budget account. And I'd be happy to answer any questions.
Thank you so much for the really interesting presentation. There's nothing like captive insurance first thing in the morning during deadline week. Do we have any questions on SB 503? I'm almost scared to say it does seem pretty straightforward. Okay, I don't see any questions, so we'll thank you so much for the presentation. We'll have you take a step back from the table, and we will welcome any testimony in support of Senate Bill 503. Seeing no one in our physical locations, AVH, do we have anyone on the phone lines in support of SB 503?
Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. Do we have anyone in opposition of SB 503? Not seeing anyone in our physical locations, we are back to you broadcast. Anyone in opposition of SB 503?
Chair, you have no callers at this time.
Okay. With that, anyone in neutral on SB 503? It's the one time you won't be coming up in neutral on an insurance bill. All right. Anyone on the phone lines? AVH.
Chair, your public line is open and working. You have no callers at this time.
Thank you so much. Would you like to make any closing remarks on SB 503? Welcome back.
Madam Chair, members of the committee, thank you for the indulgence. Just wanted to take this opportunity one last time to say the Division of Insurance has reviewed the provisions of Senate Bill 503, and we do not review them as triggering federal defrayal provisions. Thank you.
All right. Thank you so much. And with that, we will close the hearing on Senate Bill 503, and we will move to the next item on our agenda, which is the work session. And we are going to do a few work sessions this morning, two of which are listed on the agenda. And we're going to start with Senate Concurrent Resolution number 5, which recognizes antimicrobial resistance as a public health crisis and encourages certain actions to be taken in response. And I have a question before we actually get started with this, and I'm going to have Mr. Musgrove come up because I know this has been asked by a few committee members, and I do want to get it on the record, though some emails went back and forth in regards to if there's a profit for your clients in regards to SCR 5.
Thank you, Chair Pizzina. Dan Musgrove with Strategies 360 on behalf of our client B.O. Mary U. The answer is we are in this space already performing testing. And the policy of the company is that we want the nation, the world to be understanding of where AMR is going. It's still increasing. And by making it public and a thoughtful process by public health agencies, we hope to see that reduce, which in the long run would lessen the amount of testing that we do. I mean, we are in this space now, so if you test, it might be one of our machines that do that testing. So, but our belief is that this resolution is putting forth a public health idea that we need to go further. In fact, there was a news article just yesterday that the World Health Organization is revising their 10-year plan on AMR because they are seeing a proliferation across all of the countries that they are involved in. And so it's a problem that's not going away. So we are profiting from it right now, but we would ask that we as health agencies and stewards of the process try to lessen that. And so in the long run, I think we would actually make less revenue. I mean, it's a position of this family-run company that they want to see people healthier, and that's why they've asked lobbyists like myself to go around to states and ask them to take on these initiatives.
Do we have any questions from the committee? Senator Lang.
Thank you. I think the other question that people have talked about is I see that the primary sponsor of this bill is Ledge Ops, and how that happened that Ledge Ops is sponsoring this bill and no one from Ledge Ops was here to help present or anything.
Chair Pizzina, Dan Musgrove, through you to the senator.
You can go direct. Thank you.
This was something that I went to Senate leadership on to ask about the possibility of a resolution for this, and they asked Ledge Ops to introduce it because that's the normal process, and I was actually shocked that it didn't go to Ledge Ops, but or even health, but instead it came here, and I'm not sure what that decision was, but it was really me just working with Senate leadership, looking for a vehicle to get this information in front of legislators so that you would see it hopefully as something that you would want to promote. And to the initial question, we also revised, as you can see in the amendment, there was a line in there that talked about financial incentives to do testing, and we thought that was self-serving. And so to our point, we want this about health information and eradicating. And so really that was our full intent, was really just to get this information out to legislators and the health agencies that they oversee.
Okay, any further questions? Senator Ellison.
Thank you, Madam Chair. Looking at the bill, the only problem I had was that section, if you look at the front page of the bill, 17 to 20, that was a problem that jumped up and occurred, and that's been removed. Is that correct?
Dan Musgrove, yes, Senator. In my discussions with Dr. Titus, Minority Leader Titus, that was of great concern as a health provider, that it was a very blanket defamatory statement. And so we believe that it ought to be removed, because that was not our intent, was to somehow cast blame on the proliferation of antibiotics, but really that we just want folks to be aware of this pressing problem that we all face.
Yeah, and I want to thank you for, that's the only thing I've heard back on it, was that one little section, and okay, thank you.
Okay. I don't see any further questions. So with that, we are going to move into our work session. And I'm going to have Mr. Coulombe get us started with Senate Concurrent Resolution number 5.
Thank you, Chair Pazina. Jeff Coulombe from the Legal Division. As nonpartisan staff, as Mr. Ashton always says, I can neither advocate nor oppose any measure. As you have just heard some conversation about, Senate Concurrent Resolution 5 recognizes antimicrobial resistance as a public health crisis and encourages certain actions be taken in response. It was heard on May 22nd, 2025. There are 2 proposed amendments. As we just heard, to delete on page 1, lines 17 through 20, the whereas clause concerning the overuse and misuse of antibiotics, and on page 2, line 24 and 25, in the second resolve clause, the phrase providing incentives to providers for utilizing rapid diagnostic testing.
All right. Thank you so much, Mr. Coulombe. Do we have any questions from the committee? Okay, seeing none, I'll entertain a motion to amend, do pass SCR 5.
Motion to amend and do pass.
Second.
Wonderful. We have a motion from Senator Daly, a second from Senator Flores. Is there any further discussion? Yep, Senator Steinbeck.
Thank you, Madam Chair. I'm going to vote yes, so I reserve my right to change. Thank you.
Okay, thank you so much. Okay, and we have that from Senator Ellison as well. All right, all in favor, please say aye. Aye. Any opposed, say nay. Okay, the motion carries. Thank you so much, and I will assign the floor statement to Senator Daly. All right, with that, we are going to move on to the work session of Assembly Bill 555, which establishes provisions relating to the coverage of prescription insulin drugs under certain policies of health insurance. And I'm going to hand it over to Mr. Coulombe.
Thank you, Chair Pazina. Assembly Bill 555 prohibits certain private health insurers from imposing a deductible, copayment, coinsurance, or other cost-sharing obligation greater than $35 for a 30-day supply of a prescription insulin drug. The bill does not apply to coverage provided by a health maintenance organization or managed care organization to recipients of Medicaid or insurance under the Children's Health Insurance Program or government employees and their dependents. The bill was heard May 21st, 2025, and there are no amendments.
Thank you so much. Do we have any questions? Okay, seeing none, I'll accept a motion to do pass Assembly Bill 555.
Motion to do pass.
Thank you so much from our Vice Chair. Do we have a second? A second from Senator Scheibel. Any discussion? Okay, all in favor, please say aye. Aye. Any opposed, say nay. And the motion
Madam
carries.
Chair.
Oh, sorry.
I am an aye on this, but I'm going to reserve my right.
Thank you so
Okay,
much.
thank you.
Thank you so much, Senator Ellison. All right, so please note that the motion does pass unanimously. However, we did have Senator Ellison reserve his right, and the motion carries. I will take the floor statement for this one. And next, we will go to SB 503, which was just heard here in committee today on May 28th, 2025. SB 503 eliminates the account for the regulation and supervision of captive insurers and the Fund for Insurance Administration and Enforcement, and was presented by Mr. Plain with the Division of Insurance. With that said, do we have any questions? Okay, I will entertain a motion to do pass SB 503. Thank you. I have a motion from Senator Scheibel, a second from Vice Chair Daly. Any further discussion? Okay, I don't see any. So all in favor, please say aye. Aye. Any opposed, say nay. Okay, please note that the motion carries, and that will take us to the end of today's work session. We may need to meet again, or we may not. I guess we will figure that out as time goes. But right now, we are going to open up for public comment. So if anyone would like to make public comment. Oh, a floor statement for 503. That will go to Senator Flores. All right. And with that, we will go to public comment. I don't see anyone coming forward here, and I still don't see anyone even in the room in Las Vegas. AVH, do we have anyone on the phone line who'd like to make public comment today?
Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. As this may be, and we never know, but this may be our last meeting of Commerce and Labor, I would like to say a really huge thank you to a number of people, from the committee members that have worked so hard here all session. I'm so incredibly grateful for all of the work that you've put into this committee and the thoughtful judgment on the many bills that we've heard. I'd also like to thank our staff, from Mr. Ashton and Mr. Coulomé to Terry Miller, our committee manager, our phenomenal committee secretaries. Lynn's not in the room right now. Our amazing IT staff who's been working so hard all session long, making sure things run so flawlessly. Our broadcast team, security, everyone who's played a part, from the bottom of our hearts, we really thank you for everything you've done to make this session and this committee run so well. So thank you all. And with that, we are adjourned. Oh, wait.
Madam Chair, thank you. And on behalf of myself and I think the other members of the committee, also want to thank you for your work as chair on this committee. I know it's a lot of work, sat in several of the meetings, wasn't able to make them all, and you did a good job doing the work of this committee. So I think we all thank you for that.
Thank you so much for the kind words. And with that, we are adjourned.